Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Hello, everybody. Thank you for joining Synergy's Third Thursday of the Month webinar. I am Rasa Fumagalli. I'm an attorney licensed to practice in the state of Illinois, and I'm Synergy's Director of Medicare Secondary Payer Compliance. Just by way of background, my practice has focused solely on MSP compliance for the past 12 to 13 years. Before that time, I focused on workers' compensation insurance defense. I do have to confess that it is refreshing to be able to help injury victims and their attorneys try to figure out this complicated Medicare secondary payer compliance space. Today's presentation is going to focus on an exploration of several options for conditional payment resolution. At the end of the presentation, there will be time for questions and answers. For those who may be new to Synergy Settlement Services, Synergy offers a comprehensive suite of services that help you address all of your Medicare secondary payer compliance issues in a case. In addition to conditional payment resolution, we offer our Medicare Expert Case Evaluation, MECE Consult, as well as the preparation of allocations or life care plans. We provide Medicare set-aside administration services, trust services, structured funding, and other services as well. Today, we're going to be taking a look at Medicare liens in general, as well as some best practices for addressing them. We're going to go over the Medicare lien process, as well as a few of the different ways that you can address conditional payments. We're going to look at, of course, the removal of unrelated charges, self-calculated conditional payment amount process, fixed percentage option, and the full or partial waiver solution. As mentioned earlier, there will be a question and answer session at the very end. Let's start with a general look at Medicare. So Medicare is a federal health insurance program that is available to individuals who are 65 years and older. It may be available to people that are younger than 65 if they are receiving Social Security disability benefits. There are certain conditions that qualify you for Medicare by virtue of the condition, such as end-stage renal disease. Here is a snapshot of what a Medicare card looks like. There are 4 different parts to Medicare. The traditional or original Medicare is Medicare coverage under Parts A and Part B. Part A Medicare benefits include hospital insurance. It would also include a specific period of time in a skilled nursing facility. It covers hospice care and some other home health care. There are specific requirements for this coverage. However, there's also the traditional Medicare Part B plan coverage. This covers certain physician services, outpatient care, medical supplies, and preventive services. So the way that this works is that you have physicians who participate in a Medicare program. They essentially contract with Medicare and agree to accept a specific fee in exchange for the service provided. There are also Medicare Advantage plans, and these would include plans under Medicare Part C and Part D. So the Medicare Part C plan is going to include all of the coverage that is provided under traditional Medicare, plus there may be some additional services that are included, such as vision plans and dental plans. The Medicare Part D plan is a drug plan, which covers prescription drugs. The Advantage plans are administered by private insurance companies that are paid a fixed amount each month by Medicare. The amount that they receive each month is tied to some of the specific demographics of the beneficiaries that are enrolled in their programs. For example, they would be looking at the types of comorbid conditions that the beneficiaries have that are enrolled within a specific plan when deciding how much these plans should be reimbursed by Medicare. What is interesting is that there has been a significant increase in all of the Medicare beneficiaries that have elected to enroll in Medicare Advantage plans. In 2020, 39% of all the Medicare beneficiaries were enrolled in a Medicare Advantage plan. So these plans are also using the Medicare Secondary Payer Act as their recovery vehicle for conditional payments. So let's take a look at the Medicare statutory liens. And the Medicare lien statutes are pretty complicated. The basic concept, however, is that Medicare is a secondary payer in certain situations. And Medicare is a secondary payer when payment has been made or can reasonably be expected to be made under a workman's compensation law or plan of the United States or state, or under an automobile or liability policy or plan, including a self-insured plan, or under no-fault insurance. And given this status as a secondary payer, there are also other sections in the Code of Federal Regulations that specifically list that there are exclusions from Medicare and limitations on Medicare payment. So for example, Section 411.20 specifically notes that Medicare is precluded from making payment for services to the extent that payment has been made or can reasonably be expected to be made under any of the following: workers' compensation, liability insurance, no-fault insurance. There is an exception to this when it comes to situations where a Medicare beneficiary is not able to get medical treatment because payment is not reasonably expected to be made promptly or within 120 days of receipt of the claim by the primary payer. So Medicare has indicated that they will make payment in those situations. However, that payment is a conditional payment which has to be reimbursed to the appropriate Medicare trust fund. The Medicare statutes also provide that a primary payer's reimbursement obligation to Medicare can be demonstrated by a judgment, a payment conditioned upon the recipient's compromise, waiver, or release, whether or not there is a determination or admission of liability of payment for items included in a claim against the primary payer or by other means. So the fact that a payment or a settlement is made, that fact in and of itself is enough for Medicare to claim a secondary payer status. By virtue of a beneficiary's enrollment in the Medicare program, they are obligated to advise Medicare when they are in an accident where another party might be responsible for the treatment. So, as noted, the Benefits Coordination and Recovery Center is the contractor that is responsible for making sure that Medicare gets reimbursed for the conditional payments. If you have a workers' compensation situation, there is a different contractor involved, and that is the Commercial Repayment Center, or the CRC. And they essentially run the conditional payment recovery process until the case settles, and there is a Section 111 total payment obligation to claimant report that is made by the workers' comp insurance carriers, RRE, or responsible reporting entity. So Medicare essentially is making this conditional payment so that the beneficiary gets the treatment that they need and they do not have to use their own money to pay for the services. As noted before, this payment is made on the condition that it is going to be repaid to Medicare when there's a settlement, judgment, award, or other payment. And this conditional payment is essentially a way to help the beneficiary after they've had an accident, because technically Medicare is not responsible for this treatment. So what happens if Medicare is not reimbursed or repaid the conditional payments? 42 CFR section 411.24 clearly sets out the parties that can be pursued in that situation. CMS has a right of action to recover its payments from a primary payer, a beneficiary, a provider, a supplier, a physician, an attorney, a state agency, and a private insurer that has received a primary payment. Because Medicare can pursue all of these parties, this is why people take the reimbursement obligation seriously. Well, how does Medicare actually proceed with recovery? So the Medicare Secondary Payer Act has a provision that is called the Private Cause of Action provision, and it allows for double damages when a primary payer fails to reimburse a secondary plan for conditional payments. And the language specifically states that there is established a private cause of action for damages, which shall be in an amount double the amount otherwise provided. In the case of a primary plan which fails to provide for primary payment or appropriate reimbursement in accordance with paragraphs 1 and 2A. And this private cause of action provision is the MSP Recovery vehicle that is used in situations where conditional payments are not reimbursed. As I mentioned earlier, at this time, about 39% of all Medicare beneficiaries are enrolled in a Medicare Advantage plan. And because of this, it is really important to be mindful that the private cause of action has been extended to Medicare Advantage plans. 42 CFR for section 422-108F specifically states that Medicare Advantage organizations will exercise the same rights to recover from a primary plan, entity, or individual as the Secretary exercises under the MSP regulations in subparts B through D of Part 411 of this chapter. So as a practitioner, it's important to understand the difference between a final conditional payment demand, which is a fixed amount, as opposed to an interim conditional payment number, which may change. It's also important that you realize that you cannot get information on Medicare Advantage plan payments in the same way as you can secure traditional Medicare Part A and Part B payments from the Benefits Coordination and Recovery Center. So the Medicare beneficiary's report of a claim to the BCRC will result in the BCRC providing conditional payment information under Medicare Part A or Part B. If you want to obtain information regarding the Medicare Part C and Part D payments, you're going to have to go to the plans themselves. And another thing that you should consider and you should be mindful of is the fact that there are two different types of reporting going on when it comes to liability cases and workers' comp cases. So a Medicare beneficiary has an obligation to report an accident to Medicare, and this obligation is part of their process when they enroll in Medicare. And that is a very different type of report than the report that is done by the responsible reporting entity for a primary plan under Section 111. Section 111 reporting is a mandatory insurer reporting obligation that is placed on the defendant and the RRE for the primary plan. When a case involving a current Medicare beneficiary settles and it's a liability case involving a physical trauma, and the settlement exceeds $750, the primary plan's RRE is going to make their Section 111 Total Payment Obligation to Claimant TPOC report. Another thing you have to be aware of is that when you have a case that has actually been in your office for an extended period of time, it's quite possible that you may have a situation where your client, the Medicare beneficiary, has enrolled in different plans over the life of the claim. He may start out enrolled in a traditional Medicare Part A and Part B plan. 3 years go by, he may switch over to a Medicare Advantage plan. After another year or so, they might switch back to traditional Medicare, or they may enroll in a completely different Advantage plan. So it's important to stay on top of the different types of coverage that the Medicare beneficiary may have over the life of the claim. A few best practices tips when it comes to avoiding problems with conditional payments is to request copies of the Medicare beneficiary's health insurance cards at time of case intake. You should also request updated information during the life of the claim. If you are looking at the medical records, the billing statements will often identify the plans that are being billed. You can similarly see this type of information when you're looking at pharmacy records. We do recommend that you begin the investigation early. If you have a Medicare beneficiary who doesn't really, have a good recollection of the various plans that he has been enrolled in, the mymedicare.gov website is a pretty good resource where your client can sign up for an account, and it's actually going to show the plans that they have been enrolled in. The Provide Accurate Information Directly Act, also known as the PAID Act, was passed into law in December of 2020. What this PAID Act legislation does is that it requires CMS to provide information upon request to a non-group health plan regarding a beneficiary's enrollment in a Medicare Advantage plan or a Medicare Part D plan during the preceding 3-year period. And this information is going to be accessible through the Section 111 reporting database. And even though this information will be provided to the defendant, to the primary payer that is doing the Section 111 reporting, as I mentioned earlier, you as a person who's representing the Medicare beneficiary could access this information through mymedicare.gov. But it will now be easier for defendants and primary plans to identify the various Medicare Advantage plans that may have an interest in seeking reimbursement of payments that were made. At this time, we are now going to switch over and start looking at the actual Medicare lien process. So anyone who has ever dealt with Medicare liens in the past would have to agree that it is a very time-consuming process, and it's also quite frustrating. There are many different parts involved in securing the final conditional payment information. There are also deadlines. If you have any issues or problems with securing the conditional payment information, it's very difficult to get an answer from anybody when you call on the phone. Oftentimes, you're also going to get conflicting information. This conditional payment recovery process is also complicated by the fact that you may have the defendant's responsible reporting entity reporting conflicting information when it comes to the injuries that were settled, the dates of loss, and that is especially true in a medical malpractice claim where you can have different accident dates that people are using. So in order to try to make that piece a little bit more efficient, it is beneficial at times for plaintiffs and defendants to actually agree and confirm that a specific accident date will be reported and that the settlement is involving a specific condition. The next few slides are going to address the Medicare lien process. The information has been taken from the Medicare website, which is pretty decent when it comes to Medicare secondary payer information. So the way that you initiate the Medicare lien process is to have the Medicare beneficiary report the case to the BCRC. And this reporting obligation kicks in whenever there's a pending liability, no fault, or workers' comp claim. The report of the claim is the very first step in the whole Medicare secondary payer recovery process. The information that you're going to have to report is going to include your client's or the Medicare beneficiary's full name, Medicare number, gender, date of birth, complete address, and phone number. You are also going to have to share information regarding the type of claim, the insurer or workers' compensation carrier's name and address, the description of the alleged injury, illness, or harm. And I would recommend that there actually be a discussion and some coordination to make sure that the injury which is being reported is really one that can be tied into the accident. And of course, you are also going to have to report the date of the injury or the accident. The Medicare Secondary Payer Portal is a very helpful tool when it comes to conditional payment recovery. Synergy uses it often. You can actually provide this first report via the Medicare Secondary Payer Recovery Portal, and here is a screenshot of what it would look like. Once the initial Medicare Secondary Payer Occurrence event is posted, the BCRC is going to send the beneficiary the rights and responsibilities letter. It essentially explains how the recovery process works and what information is going to be needed from you and what information you can expect from the BCRC. This is a screenshot of what the letter looks like. The next thing that happens is that Medicare is going to start looking at payments that were made in connection with the diagnosis code or injury that was reported to them. So they are going to start their search from the date of incident, and they are going to provide a temporary figure which is subject to change, and this would be called the conditional payment letter. Here is a screenshot of what the conditional payment letter will look like. As you can see, the letter states that, for example, as of the date of this letter and based upon available information, Medicare has identified $2,795 in conditional payments that we believe are associated with your case. Further down in the report, it talks about that they are still investigating the case to obtain any other outstanding Medicare conditional payment information, and it specifically indicates that this information is not final. So when you receive a letter like this, you should not rely on this figure as being the final figure. It clearly states that this is an interim figure. This is an example of a payment summary form. As you can see, there are different line items and they reflect ICD diagnosis codes. It's important to review the diagnosis codes to make sure that they're consistent with the type of injury that was sustained in the accident. If there are numerous diagnosis codes listed on one line, typically the code that is bolded is the main diagnosis code, and the remaining codes are simply part of an electronic record. This is, however, an area that can be reviewed and disputed during a conditional payment dispute based on whatever the medical records may show. As I mentioned earlier, the Medicare Secondary Payer Recovery Portal is a nice tool that allows the conditional payment recovery process to flow a bit more smoothly. These are some of the features that are available through the use of the portal. You can essentially submit the proof of representation, the beneficiary consent to release, or the insurer letter of authorization. You can request conditional payment information. You can request copies and actually print out the conditional payment letters that were issued in the claim, you can also dispute the claims. These are some other things that you can do on the portal as well. You can initiate a demand letter. You can submit case settlement information. You can also submit a waiver, compromise, or redetermination request. There are other options when it comes to conditional payment amounts. There is the self-calculated conditional payment amount, which is available under certain specific facts. It only applies to physical trauma-based liability settlements. The settlement must also be less than or equal to $25,000. The date of incident also has to be at least 6 months prior to submission of the self-calculated amount, and there are also specific timelines that must be followed. This is a copy of what the self-calculated conditional payment amount model language looks like. It's available on CMS's website, and it seeks information regarding the nature of the settlement and so forth. The fixed percentage option is also available for physical trauma-based liability settlements. This feature is available when the settlement is less than or equal to $5,000. There are also specific timelines associated with this option. I've attached a copy of what the model language for this fixed percentage option looks like. Sometimes Medicare does not issue a conditional payment letter and they instead issue a conditional payment notice. This usually happens when there is a Section 111 total payment obligation to claimant report by the defense or the responsible reporting entity. And this is issued when a settlement, judgment, award, or other payment has already occurred. So if there is a conditional payment notice, it's really important to respond to it within 30 calendar days. If you do not respond to it, then you are going to get a demand letter and they are not going to give you a proportionate reduction for fees or costs. So when you receive a conditional payment notice or a conditional payment letter, there are ways to dispute the claims, and the basis for the dispute would be to request a removal of the charges because they are unrelated to the claim. You can do the dispute through mail, through fax, or through the Medicare Secondary Payer Recovery portal. If the BCRC agrees with your dispute, they will send an adjusted conditional payment amount. When the case fully settles, there's an obligation on the part of the beneficiary to report the settlement, judgment, award, or other payment to the BCRC. There are specific things that have to be reported, such as the date of settlement, amount of attorney's fees and other procurement costs that are borne by the beneficiary. And there is a final settlement detail document that can be used to make this easier. This is what the final settlement detail document looks like. So once the case has fully settled and Medicare issues a final demand, it's important to realize that the conditional payment demand may include charges that were not reflected on the conditional payment letter. They're essentially going to do another database sweep from the date of accident to the date of the settlement, judgment, award, or other payment. And once this final demand is issued, there's going to be a formal recovery demand letter that is sent by the BCRC seeking recovery of the demand amount. Once you have the demand, the options are to either dispute it or pay it. If you do not repay the debt or dispute it within 60 days, you are, or whatever time frame may be reflected if the process changes, interest is going to be assessed for each 30-day period the debt remains unresolved. And interest is going to accrue on the outstanding principal portion of the debt. If you appeal the demand, interest is still going to accrue. So really, Medicare recommends, and from a practical aspect, it is recommended that you consider paying the demand so that you can stop the accrual of interest. And if you prevail on the waiver or appeal request, you will receive a full refund. If you do not act on the demand letter, what is going to happen is there is going to be an intent to refer the debt to Treasury. And the intent to refer is sent on day 90 after the date of the demand letter if full payment is not received. And the CMS may then also refer the debt to the Department of Justice for legal action. As I mentioned earlier, the private cause of action allows for double damages in situations such as this. There are two ways to reduce the final demand. There are reductions for procurement costs. One is to simply reduce the fees and costs from the Medicare lien amount. And the second is to reduce the fees and costs from the settlement, and the remainder goes to Medicare then, essentially leaving nothing for the plaintiff. So these two methodologies, however, do not take into account any liability-related issues, such as caps on damages or low policy limits and so forth. The goal of the Medicare Secondary Payer Statute is really to maximize the return of the funds to Medicare. They are not really concerned about the well-being of the Medicare beneficiary. The next two slides provide the statutory basis for this type of reduction. So what other options are there for further reduction? So there's option one, which is submit an appeal. If the final demand remains unpaid, you're going to have interest accruing. The other option is to pay the final demand, and the benefit to this is that the interest stops accruing while you are requesting a waiver or a compromise. When you are looking to have Medicare accept less than the full amount of the final demand, there are three different statutory provisions which you can reference. The first is under Section 1870C of the Social Security Act, which allows for a financial hardship waiver. The second is under Section 1862B of the Social Security Act, and this is a waiver for the best interest of the program. The third provision that you can point to is under the Federal Claims Collection Act, and this request can only be considered by CMS. The Section 1870C provision allows CMS to waive all or part of its recovery for the beneficiary who is without fault, and without fault has a definition under the Social Security Act. And the second component of this waiver criteria is the adjustment or recovery, if pursued, would either defeat the purposes of the Social Security Act or be against equity and good conscience. The definition of at fault, according to 20 CFR section 404.507, states that in deciding whether an individual is at fault, the administration is going to look at the individual's age, intelligence. They're going to look at physical, mental, educational, or linguistic limitations. So presumably you can make a very compelling argument that your client was not at fault when it came to this conditional payment or overpayment that was made by Medicare, and ideally in a specific appropriate fact pattern, this will be a persuasive argument. Under this section of the Social Security Act, the BCRC is able to grant full or partial waivers to beneficiaries when repayment of the conditional payments would pose a financial hardship. In order to apply for this, the Medicare beneficiary is going to have to file a form with the BCRC, which documents their financial situation. Synergy also recommends and includes a letter that is drafted by the Medicare beneficiary, not their attorney, explaining the undue hardship that repaying Medicare would cause. In considering the Medicare beneficiary's financial hardship request, the BCRC is going to be looking at their living expenses. They're going to be looking at the medical, hospitalization, and other expenses. For example, are there costs that are being incurred and are not covered by Medicare, such as custodial care? They're going to be considering whether the beneficiary has children and they are legally responsible for the children, as well as other miscellaneous expenses, which would be reasonably considered to be part of the beneficiary's standard of living. The second statutory provision, which could be referenced when you're seeking a waiver, is under Section 1862 B of the Social Security Act. And basically, this is an evaluation by CMS that a waiver is appropriate since it is in the best interest of the program. And the best interest of the program can consider a few things. One of them is whether or not this would be against equity and good conscience. And secondly, they would be looking to see whether there would be a financial hardship by depriving a Medicare beneficiary of the income that they need for their ordinary and necessary living expenses. The best interest of the program financial hardship evaluation is going to be very similar to the request for a waiver or compromise under Section 1870C. You are once again going to be showing that the Medicare beneficiary has limits in terms of, their finances, that they have a certain amount of fixed living expenses. They have other people they're legally responsible to support, as well as other expenses that they're incurring, such as medical and hospitalization and other miscellaneous expenses. This particular best interest of the program argument will also have the BCRC looking at some other factors, such as the degree to which the beneficiary contributed to causing this overpayment. They're going to look at whether their own contractors contributed to this overpayment. They're going to consider the undue hardship for the beneficiary, whether the beneficiary would be unjustly enriched if there was a waiver, and whether the beneficiary actually changed their position to their material detriment as a result of receiving the overpayment or as a result of relying on the wrong information that they're being supplied by Medicare. The third statutory authority, which you can cite to when you are looking to have Medicare accept less than the full amount of the claim, is under the Federal Claims Collection Act. And this particular provision requires CMS to actually be the entity or agency that is going to make this determination on whether or not a compromise will be granted. And this provision allows federal agencies the right to compromise the amount that they're seeking under certain circumstances. And they look at whether the cost of collection would not justify the enforced collection of the full amount of the claim. They consider whether there is an inability to pay within a reasonable time. And then they look at the chances of successful litigation to see if they are questionable or not. And all of this information is listed in the updated Medicare Secondary Payer Manual, Chapter 7, Section 50.3. There are a couple of things to be aware of when you are considering this type of a compromise request. The first is that CMS has the authority to compromise these claims up to $100,000. If you are seeking a greater than a $100,000 reduction or compromise, CMS is going to be working with the Department of Justice. And MSP Recovery contractors do not have the authority to consider compromise requests under this provision. Synergy has been extremely successful in presenting these various arguments to CMS and to the BCRC. For example, in one of the cases that we handled, we had a slip and fall case on a parking curb. The Medicare beneficiary sustained a broken wrist, a broken pelvis, and a bruised kidney. The round-the-clock caregiver expenses were paid out of pocket. The case settled for $115,000. Medicare's final demand was in the area of $22,000. Synergy extended and offered a compromise of $100, which was accepted by CMS. So the claimant essentially got a refund of $22,310.72. Synergy also had a 100% recovery in a case where there was a medical malpractice action. The Medicare beneficiary's income was quite low. The request that was made was a financial hardship waiver. The Medicare beneficiary was caring for her daughter and her granddaughter, and she was essentially paying for them. The settlement of $300,000 was reduced to a net settlement of $157,000 after fees and costs were deducted. Medicare's conditional payment letter was $73,000. They made a final demand of $38,000, which was actually paid. When Synergy presented a financial hardship waiver request, all of the funds were reimbursed and they were placed in a special needs trust. When it comes to conditional payments, Synergy provides a Medicare audit and verification service to our clients. We essentially take the Medicare reporting and auditing process off your plate while you focus on what you do best. We are making sure that the injury victim is able to retain as much of their settlement proceeds as possible. Other things that we do in addition to the waiver and compromise options, which we just discussed, is we are able to work with you to secure final conditional payment information prior to mediation or settlement using the final conditional payment process through the Medicare Secondary Payer Recovery Portal. Synergy's waiver compromise refund service has a very good track record for success. The way that we're able to do this is we review the case on the front end, and based on our expertise, we can usually tell whether or not we're going to have a successful result or not. After you pay the final demand and your case is technically closed, we can work on behalf of your client seeking a refund. Any refund which we can achieve is actually an unexpected gift to your client. So that is a win-win for all that are concerned. So now we've reached the end of the slides, and let's see if there are any questions. Thank you for your time. So I am looking to see if there are any questions that are posed in the chat box. And at the moment, I do not see any. So if you do come up with any questions once this presentation is fully completed, please do reach out to us and we'd be happy to address them. Thank you for your time and for your attention.